Good afternoon, everyone. Welcome to the Appellate Division First Department. I think everybody is familiar with the procedures here. Again, please ask for the time that you actually require to bring out the salient portions of your argument. Please know that we have read your briefs. We are fully familiar with your arguments, okay? This says that there are more than 5 hours of argument time requested, so that would bring us to 7 o'clock, right? So, not happening, okay? Just so we're clear. People v. Doblin, that matter is submitted. Goldman v. Chop It, Creative Salad.
On submission, we both agreed.
I'm sorry?
We both agreed on submission.
Excellent, excellent. See? Everybody take note. Matter of Onalia, submitted. Excellent. Lynch v. Hub International. Oh, wow. You broke the chain. We were doing so well, and you broke it. I'm sorry. 5 minutes?
Responded 5 minutes.
You have a cross appeal, right? Did you want time of rebuttal?
2 minutes.
525. People v. Freddie Padilla. That matter is submitted. Welman versus Tremont Renaissance.
So for appellate respondents, Tremont, that group of
Urban, 5 and 2.
5 and 1 and 5 and 2. Beach v. Tajaldi. I'm sorry. Oh, I'm sorry. The rest of the people.
plaintiff responded 2, and NYC responded 3.
Are you on that one too? Oh, you're Beach. Okay. So Beach, you're going to be. Go ahead. Okay, so we figure this out now. So do I have 2? 5 and 1. I'm sorry. On Beach, could we do Beach again? Okay. So in that matter, Justice Singh is recused on that matter on Beach. Okay. And then we have 5 and 2 and 5 and 2. Hassan versus Terrace Acquisitions. 5, 2, and 5. The Mattis Dakron versus the City of New York.
David Westman for appellant, 7 and 3, please.
Kate Fletcher, City of New York, 5, please.
6, 2, and 5. Simpson versus Pasha Enterprises.
I realize the respondent is not here in this case. If the panel has any questions, I'll be happy to stay and answer them. If the court will give me a minute or 2. Otherwise, if there are no questions, I'm happy to stay.
I do not believe there are any questions. Thank you. That matter is submitted. MacArthur v. Doblin. And your virtual respondent?
Yes, Your Honor, I apologize, I didn't hear how long the appellant requested.
7 and 3.
Thank you, we would request 7 as well.
6, 2, and 6. Bay Plaza Mall versus Argonaut Insurance.
Afternoon, Your Honor. For appellants, 5 and 1, please. For responding, cross appellant, 5 on the response and 5 and 1 on the cross appeal.
And
Cross respondent, Tremont, I would request
5
5 minutes.
and 1, 4 and 1, and 4. People v. Robert Ortiz. That matter is submitted. Hardy versus Hardy. That matter is submitted. Shepard versus Workman Circle. That matter is submitted. Let me just go back to Welman v. Tremont. I have 5 and 1 and 5 and 2. Okay? Thank you. So the first matter for argument is, as I stated, MacArthur versus Doblin. Okay, you may proceed.
Thank you, Your Honor. Good afternoon. May it please the court, John Golashevsky on behalf of the appellant. This court should reverse the summary judgment order because the trial court misconstrued the evidence, ignored black-letter New York law, and repeatedly contradicted itself. In granting plaintiff summary judgment on his breach of fiduciary duty claim, the court referenced a line item in a tax return of $145,000 and stated, MacArthur argues this was never repaid. This despite repeatedly admonishing plaintiff throughout the order for, quote, failing to discuss the issue of damages in his opening brief. Thus, we lay this out in our papers. This court can scour the summary judgment record. There is no argument from the plaintiff that the $145,000 was not repaid. The only evidence concerning repayment at summary judgment was the affidavit of my client, Mr. Doblin, who testified that indeed that money had been repaid. In ignoring that affidavit, the trial court ignored two tenets.
Sir, what proof did you submit that corroborated the affidavit statement that, in fact, that the 145 and change it?
At summary judgment, it was just the
At summary
testimony.
judgment.
It was just the testimony at summary judgment, Your Honor. As the non-movement, however, all facts had to be construed in favor of Mr. Doblin. In addition, the affidavit testimony by itself is sufficient because it did not contradict his prior testimony. It simply amplified his prior testimony that that money had in fact been returned. By misconstruing the testimony, what the court did was that it invented an argument.
Ultimately, isn't essentially what the court granted was partial summary judgment, correct? I mean, really on liability. Issues with respect to damages, aren't those all subject to proof at trial?
I disagree, Your Honor. The court specifically said that Mr. MacArthur had demonstrated at least $145,000 in damages to BCC. That is specifically what we addressed.
Or was a judgment entered on that damage?
There was no formal judgment,
So
but
it sounds like to me that maybe there was a reference to the claim with respect to the 145, but it was really only on liability and not damages.
well, our position is that summary judgment has been granted on liability on the fiduciary duty. Damages is a integral part of a breach of fiduciary duty claim. They can prove none, as we set out in our motion to renew, which was only filed immediately after we saw that the trial court had made this error. We have definitive evidence via the testimony of the accountant, via BCC and BCI tax returns, that of course that
So
money
you
and then
didn't
some was
submit the
repaid.
tax returns when you should have. You should have submitted maybe in summary judgment. Why can't these issues all be resolved now at the damages portion of the trial with respect to the payment?
Well, because what we have right now, Your Honor, is something going to be a very serious problem, is that there's going to be an order from the court that says $145,000 at minimum, let's be clear, at minimum $145,000 has been proven by the plaintiff. And we are going to have testimony from the BCC accountant which completely contradicts that. It's going to say absolutely not, that money was completely repaid and then some.
But my issue, or my question is, what exactly does it have to do with the claim for a breach of fiduciary duty? Have we not kind of skipped over that?
In terms of?
In terms of, I mean, as my colleague stated, the finding was partial summary judgment on breach of fiduciary duty, right?
Correct.
So again, why are we still not just dealing with damages?
Well, because if they can't prove damages, Your Honor, they can't prove a breach of fiduciary duty claim. There are no damages stemming from what we've been referring to as the Amex lockbox situation. Everything had been repaid to BCC. Now you have an order from the trial court saying absolutely not. The $145,000 was not repaid. That is an order from the court when we know definitively.
But what was claimed was that there were certain loans that were taken out without the knowledge of the plaintiff, that in terms of the Amex lockbox, in terms of another loan, I think that was taken out as well,
Correct.
wasn't it? So why would that not constitute a breach of the fiduciary duty?
Well, let's even assume for purposes of that certain prongs of a breach of fiduciary duty could be met. The absence of damages dispels any claim for breach of fiduciary duty. They can't prove any damages stemmed from this alleged breach of fiduciary duty.
Well, if there was a diversion of funds, for example, if there was a diversion of funds and that weakened BCC to a point where ultimately it collapsed, is that a damage maybe that can be proved at trial?
At summary judgment, the onus is on the plaintiff to show non-speculative damages. There is no
Well, but they
damage
didn't,
theory.
but again, I'm sorry for harking back on this for the third or fourth time now. It was only a motion on liability, not damages. I hear what you're saying, but it seems to me that you have at trial, you'll be able to establish whether or not there was a diversion, whether it caused injury to the company, et cetera, et cetera.
But, and with respect, Your Honor, that's not how we read the order. We read the order as saying that they have proven $145,000 plus in damages. That's how we read the order. Now, no judgment was entered, that's correct, but that's,
So if no judgment was entered, then you're free at the trial of the action to dispute the amount of damages, right? It was only a motion for partial liability, for a partial summary judgment on liability.
and that's correct, but as we lay out specifically in connection with our breach of contract claims, if they cannot demonstrate, even at summary judgment, if they cannot demonstrate any damages, zero damages, then
But they're
then
not
the claims have
required
to
to
be dismissed.
demonstrate damages if they're moving for summary judgment on liability. And there's always a question of nominal damages, so.
Understood. I see that my time is up. May I just address briefly the breach of contract claim? Or may I do
Yes,
so?
you can do that on rebuttal.
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. May it please the court. Raphael Nemes for the plaintiff respondent, John R. MacArthur. There are 3 points I'd like to make in response. If I may, the first is that there's no question that we established as a matter of law on the question of liability that Mr. Doblin improperly siphoned off BCC revenues to support his own company, BCI, and that caused.
Well, as you
damages.
heard, your adversary is arguing that because you were unable to or cannot show damages, therefore you cannot show that there was a breach of, it would not constitute a breach of a fiduciary duty. There would not be a breach of fiduciary duty.
Yes, Your Honor. We feel that the record contains numerous examples of both liability and damage. This $145,000 number, it's kind of a red herring that the appellant, I believe, is trying to focus on to distract from the fact that the record shows that Mr. Doblin, the appellant, had diverted hundreds of thousands of dollars as of the end of 2016, and that those revenues were not repaid according to tax returns in 2017.
So is it
and
your
2018.
position, counsel, that the diversion caused injury to the company?
Yes, Your Honor. It is. It is indeed. And another point that I just wanted to make is that there's the only documents that Mr. Doblin points to as proof of repayment of those funds are those that were offered for the first time after Justice Maisley had already entered partial summary judgment against him. And those documents claim to show that the appellant repaid the money by the end of 2019, but that's only 7 days before the BCC store closed. So it's a bit like depriving, it's the business version of depriving someone of sustenance for days, giving it back to them just before they expire and saying there's no damages here because I've provided you with all the withheld food for those days. So we feel that the record clearly demonstrates damages, and we'll prove them at trial, the exact amount. But as Your Honors pointed out, this motion was only on the question of liability, not on damages. Another point that I'd like to make, unless there's other questions, is that there's no question that Mr. Doblin has been on notice of our breach of contract allegations since the start of this lawsuit, and in response to his summary judgment motion, we met our evidentiary burden. I also just wanted to mention, with respect to the motion to renew, the defendant the appellant defendant has presented this copy of the tax return that was withheld in discovery and was not a part of the record on summary judgment. The document was in his knowledge at the time of summary judgment and during discovery, but he did not produce it and should not be allowed to do so now. And we believe that the trial court did not abuse its discretion whatsoever in denying the motion to renew. Regarding the breach of contract claim, to go back again, sorry to jump back and forth, the appellant's arguments are meritless. The appellant claims that none of our allegations are within the complaint, but this is incorrect as evidenced by the complaint itself, in which we alleged failure to disclose a loan to Mr. MacArthur in violation of the amended operating agreement. We further alleged Mr. Doblin conflated the interests of his other company and that he intertwined the operations and finances of BCC and BCI. And we also explicitly referenced the provision of the operating agreement that required unanimous approval for the incurrence of indebtedness. Mr. Doblin did not. We also, in our summary judgment motion, referenced another provision of the contract 7.03, and Mr. Doblin did not object to our mentioning that in our summary judgment motion, as noted by the trial court. Again, regarding damages, we had no obligation to present evidence of damages in our motion for partial summary judgment, which was on liability alone, but we did present evidence of non-speculative damages in response to the appellant's motion, the defendant appellant's motion for summary judgment. Regarding fraud, I just want to mention very quickly before my time is up that the appellant on appeal is trying to make this argument that it's duplicative of the breach of contract claim. He didn't make that argument on his motion for summary judgment. The one place where he raised it was in his reply brief in connection with his motion to renew and re-argue, but that was part of his re-argument, and he notes in his appellate brief that he is not appealing from re-argument and cannot do so, so we believe that issue has been waived.
Yeah, but ultimately, counsel, it may well be duplicative, no? And you would be, if you prove damages, you wouldn't be entitled to double damages. You agree with that, correct? So that's an issue, that's really an issue for trial, presumably, whether or not it's duplicative of the breach of contract, correct?
Correct, Your Honor. We agree with that, and the trial court has already ruled that there will not be double recovery on contract and fraud.
Thank you.
Thank you very much.
Just very briefly on the breach of contract claim, the only allegation of breach of contract was that Mr. Doblin violated the operating agreement by entering the crowdfunding. The court held, quote, Doblin fails to raise an issue of fact regarding consent to the fundraiser. That's why it denied our motion for summary judgment. BCI was the only counterparty to the fundraiser. BCC was not implicated. No consent was necessary. On the motion to renew, there was an error of law, a clear error of law by the trial court. The trial court said that a motion to renew has to be based on something that you didn't know about, that you didn't have in your possession. This is absolutely incorrect. Renewal is based on two issues. One, does it change the prior determination? And two, was there a reasonable justification? And this court in the...
Wait. Did you know about your accountant's true-up for the $145,000?
We did not. We had not spoken to the accountant prior to the summary judgment order because nobody had argued on the $145,000, Your Honor.
You didn't think that that might be an issue of damages?
No, there was no reason to think so. For the same reason, I mean, counsel here is referencing tax returns advanced to affiliates in 2016 of $400,000. Is that also the measure of damages? Everybody knew that money had been paid down.
So, counsel, I'm not understanding. You argued a little while ago that damages went hand in hand with the issue as to breach of fiduciary duty, right?
I'm saying that.
So you argued that they go hand in hand, that you cannot have a partial summary judgment on the breach of fiduciary duty because there are no damages. But at the same time, now you're arguing that, but you did not know that, therefore you should come forward with any proof as to damages because what?
It was their motion, Your Honor. Had they wanted to make an argument as to damages, they could have done so. The court repeatedly acknowledged that they failed to raise the issue of damages in their opening brief. Now, when we came up on renewal, what we showed was the affidavit of the accountant, which is in fact new evidence that was not in our possession.
Wait. In the complaint, there was a claim that you were siphoning off money, right, from your company to another company, and and your defense to that was, I paid it back, correct?
Correct.
And you're saying that you didn't think the tax documents with respect to that payment had anything to do with this lawsuit? And you should therefore exchange them in discovery?
They were exchanged in discovery. Let's be very clear about that. The 2019 BCC tax returns were in fact exchanged in discovery. Let's be clear. They were, in fact. They were not addressed on summary judgment because they had never, as the court acknowledged, the trial court acknowledged, they did not raise the issue of damages in their opening brief. So exactly when were we supposed to bring this up to the court?
They didn't raise it because it was a motion for partial summary.
And our point, Your Honor, and I don't want to,
Right.
respectfully, I don't want to keep going round and round, but our point
hear your
is summary judgment cannot be granted in their favor absent a showing of damages. And if I just may direct the court very briefly.
But the bottom line is that the tax returns, as it relates to the affiliate advances, they were always in your client's possession, correct?
Correct.
So yes or no?
Correct, and they were also in their possession as well.
Really? Okay.
That's correct. If I may direct the court to just the Bavona matter versus Superior Maintenance, 204 AD 2nd, 136, quote, where additional facts presented on a motion to renew relate to an issue, quote, which had not previously been raised by the parties, but rather had been raised sua sponte by the court in its memorandum, it is error for the court to not consider these additional facts. Nobody had ever argued $145,000. The second the court did so, we moved to renew, and we put this evidence which definitively establishes it was not there. Thank you very much for your time.
Thank you both. Lynch v. Hub International.
Good afternoon, Your Honors. My name is Tracy Bernstein. I represent the plaintiff appellant Lawrence Lynch. Mr. Lynch seeks reversal of a decision of the lower court dismissing his claims that respondents breached Section 3.3I of an asset purchase agreement entered into between the parties in March of 2014 based on claims that respondents acted in bad faith with the primary intent to undermine.
What is the implication of your client going through the quasi-ADR process, at least with respect to the first and third payouts? What's the implication of that based on the argument that you're making now? Are you able to make that argument after following through with that process?
Yes, Your Honor, for a couple of reasons. First and foremost, there is a provision in the APA, Section 12.3, that says a course of conduct cannot act as a waiver, either failure to act or even delay in acting. Secondly, and more importantly, if, which the court below failed to do, and I believe is error, and one of the reasons we're appealing, if the scope of that expert accounting narrow provision upon which the process took place is not covering the 3.3 primary intent claim. In other words, 3.3I is collateral to that narrow expert accounting provision, then my client going through the process would be irrelevant to this process. More importantly, because...
But I understand what you're saying, but if we were to accept that argument, essentially, wouldn't we be rewriting the agreement? Because what the agreement says specifically, that if you go through this process, that the amount is deemed to be final, binding, and conclusive on the parties. Shouldn't that language, at this point, foreclose your ability, at least with respect to the first and the third, and attempt to get around it?
Your Honor, again, I respectfully disagree. If the claim for primary intent falls outside the calculation, then this is about math. If you look at, even in this case, in this court held in Signal Capital Corp., the person went through the ADR process as well, or began it and then abandoned it. And in addition, the court noted in finding and supporting the lower court's decision there in Signal Capital Holdings, what the court said there was that if it is not part of the ADR process, you cannot be forced to bring a claim that isn't covered.
No, but counsel, we're not talking about whether or not you went through the ADR process. Your client accepted the number in a written document, and your APA says, if, at least on the first and the third, your client in a written document accepted it, and the APA says, if you accept it, it's over, it's done, we're both bound by it. The second payment, okay, it's a different thing, but the first one, you accepted the payment, and the third one, you accepted the payment. And you can't write out that section of the APA, can you?
Yes, you can, Your Honor, for this particular reason. And that is because how can you apply the final and binding language or the 30-day restriction on doing it to a claim that couldn't be brought in the first place? All my client accepted was a calculation.
You didn't have to accept it. You didn't have to send that document and say, I accept it.
No.
You could have said, I reserve my right to talk about primary intent, but I accept the calculation. That's not what your client did. Your client sent a document that says, I accept it. And the straight APA, it's not ambiguous, I don't think. Maybe you're arguing it's ambiguous, but it's pretty straightforward. If you say that language, this is it, then you're done. It's binding and conclusive on both parties.
The section specifically states that if you accept it, that means that you are accepting the calculation, and the calculation is therefore binding.
But then, Your Honor, what would happen is HUB or the respondents would be free to engage in egregious acts of fraud surreptitiously, and my client would be limited to a 30-day.
All you have to do is say, I don't accept. I accept. I don't accept the calculation. That's all you have to say.
Your Honor, under section 3.2C, it says that if he does not accept the calculation, he's still bound to it. It's final and binding whether he signs a piece of
But
paper
you went
or
through
not.
the process. See, that's, you went through the process with respects to the first and the third payments, and it seems to me that you're bound by the result, because it says specifically deemed to have accepted the amount of the earned payment.
Your Honor, I will point to the cases of SciTech Industries from the Southern District of New York in 2015, in which a defendant there or plaintiff there went through the process and then abandoned it to sue in court on a basis of reps and warranties.
Well, isn't
were
that more your
violated.
second? It's more like your second payment, which you in effect abandoned, which maybe you can address on you're at the red light, but it's. I think it's more analogous to the second earned payout as opposed to the first and the third.
Thank you, Your Honor.
Good afternoon, Your Honors. My name is Lisa Fleischman, and I represent the respondent in this matter. Your Honors, as you did note, the first and third earn-out payments were accepted, and that is deemed to be final, binding, and conclusive.
And if I may, let's take it a step further. With the first payment, there was no filing of a notice of disagreement, right?
None whatsoever.
But then, on the third, there was. And there was an explanation, and there was nothing further, correct?
There was nothing further, and in fact, the letter said to Mr. Lynch, we can invoke the dispute resolution process, and there was crickets.
And then after that, that's when it was signed, accepted, and I'm just paraphrasing, in August.
Correct, Your Honor. The plaintiff did sign off on 1 and 3. I would also...
So let's talk about 2.
Yes, let's talk about 2. The primary intent violations that are alleged as the basis for this breach of contract action are the clawback claim, the house accounts claim, and the claim that the earn-out agreements were unilaterally amended. Your Honors, the first 2, the house accounts and clawback claims, were never identified as primary intent claims in the notices of disagreement. Only now, when this complaint has been filed, are all 3 being called a primary intent violation. So,
Well, I mean, that letter says, I am challenging your primary intent for the calculations that you've done, because I think you've added in deductions or that are intended to reduce the EBITDA for net EBITDA, I guess. So I mean, I don't know that that's not saying specifically what it is in that letter would make that claim not viable.
Respectfully, I believe it does make it viable because the primary intent language is only with respect to that third allegation. And back when these letters were filed, that's the time period that mattered. There were only 70 days within which the dispute resolution process could be invoked and done. And back when it mattered, the plaintiff only said one of these three claims is a primary intent violation. I'm referring to the second.
Did you make that argument below?
We did not, but as I
Okay,
explained
so that's
in my
because I
brief-
didn't see that at all. The trial court didn't deal with it, and
I made it in
let's
my
assume-
brief.
I think the arguments you made below was that all of it was covered by the dispute resolution claim, right?
Yes, we did make that,
right.
and I'll address that as well. But I did say in my brief that if it's apparent on the record, then this court can consider it and can consider it in the interest of justice. It is important because it does go to how his positions have changed in this matter. This is a lot of revisionist, historical revision. I would like to address the claim that the no waiver clause applies here. It does not apply to Section 3.3, the earn-out agreement section. That section has built-in waivers all around. All roads lead to a final binding and conclusive determination, so therefore it cannot apply to the general provision.
Counsel, this is what bothers me with respect to the second payout. You take you say that it's waiver essentially as a matter of law.
Yes.
And then the case law really, frankly, doesn't support that position. Waiver is generally known to be understood to be an issue of fact for a jury. How can we make that determination here, even if, say, you go through discovery, there's a motion for summary judgment, which put it on a different posture, on how does this utterly refute, first, plaintiff's claims, at least with respect to the second payout and primary intent?
It refutes it because we moved on documentary evidence.
Well, I'm saying, how does it utterly refute their claims? You have a provision in the contract which you say doesn't apply, but it says no waiver. Why shouldn't we give effect to that language at this time and let you proceed to at least let plaintiff proceed to discovery on the second payment?
Because by his actions, he didn't invoke dispute resolution, and it does apply. Your Honors, look at the letters, pages 138 through 150 in the record on appeal. The claims below in the letters, back when it mattered, were all about accounting. They were all
Well, he says
numbers,
that there
not bad
were-
intent.
that the decrease in house accounts, overpayments of producers that negatively impacted the earn-out calculations. And he stated that was a violation, right?
Yes,
Okay.
that one claim, not the house
So,
account.
and then apparently you respond, and I guess you explain what the basis for the calculation?
Yes, what we say is that there were 3 sales producers who amended their agreements. That was it, and it had no impact.
And then plaintiff
the earn-out.
takes no further action.
Right,
That's
exactly.
to the second.
That's-
And then
that's
we
the
proceed
waiver.
we proceed to the third,
Right,
the third payout.
right. The third payout, which the plaintiff accepted. So here, by his actions and by the very clear record below, the plaintiff waived it, and under the terms of this
One
contract.
second, when you say the clear record below, this is not after discovery, right?
It's not, but
It's
these
a
are-
pre-answer motion to dismiss. You hand up a document and you say, based on this document, which actually has a no waiver clause, and a breach of contract cause of action, which is a 6-year statute of limitation, that based on your argument of waiver in the face of a no waiver clause, and your interpretation doesn't say in that section that the no waiver clause doesn't apply here. It's your interpretation, and you're saying that that's based on the big giant record below. We should grant you judgment dismissing the complaint?
Yes, Your Honor,
Okay.
because that evidence contradicts flatly the allegations of bad intent in the complaint, which only surfaced years after the time period.
No, it's a breach
started.
of your obligation of good intent, which you actually have under that contract, right? It's in there. It's not like an amorphous thing. You've said, I will not do this specifically, right?
Yes.
So it's just a breach of contract.
But it's precluded by the terms of the contract that the.
What term precludes it?
That, that this is an earnout issue and that.
You're including information in the earnout number that you agreed not to in the contract is precluded by what?
It's precluded by the record. We explained why. These are compensation claims, and employee compensation is specifically excluded from adjusted EBITDA.
Well, this is not okay.
They are, and
Well,
were he to
right.
go,
Okay, so, okay.
were he to go to dispute resolution, he would have lost. That's why he's come back years later with a breach of contract action. I'll refer your honors to 3.3b 8, which says compensation issues fall outside of earnout. I'm well beyond my time, and I apologize for that. Do your honors have any further questions or comments?
No, thank you.
Okay, thank you.
Your Honors, I'll be quick. I just have to come back to one issue, and that is, at the end of the day, this was a very narrow provision, and they hired accountants to review a calculation. Our claims are about bad faith and primary intent. They are not covered by this.
But the problem is that you go through the process. You go through the process, and the language then it has an impact because the language is really clear. When we go through the process, you're deemed to have accepted the amount of the earnout payment to be final, binding, and conclusive.
Your Honor, but that presumes that the primary intent claim falls under that process. If it's outside the process, then that language can't apply to it.
But it doesn't, the part of the 3 that says, if you accept it and say, I accept it, has nothing to do with this versus that. It's if you accept this, that's it, it's over. And 1 and 3, you accepted it. And that's what the plain language is. Agreed. On 2, you didn't. And you're arguing now that your breach of contract claim on that has to do with whether or not the intent was to lower the net EBITDA. Okay, but not with respect to 1 and 3.
But
Because
the only thing is as to 2 is that once they came back with an explanation, and their explanation seems to be that it was based upon EBITDA, and therefore it falls out of it's based upon EBITDA, they come back and they tell you this, then you don't do anything. You take no actions, and then you proceed to the 3rd one, which you accept.
Because, Your Honor, I think this goes to the heart of what one of the justices said, which is waiver is a fact-intensive claim. And so for my client to be deemed to have waived it when he got 0, there was nothing to accept, and it doesn't fall within the provision.
But 1 and 3 don't fall under the waiver provision. They just don't, because you went through the process, you accepted the amount, and all we're doing is following the language and applying the language as it's written.
And we're just going to have to respectfully disagree, Your Honor, because to me, if it doesn't fall, and that's why I pointed to the Cytec cases and this court's decision in Signal Corp, both cases, they started the process and abandoned the process. And there was no waiver found. It was because the claims are of bad faith. Otherwise, just as one of the justices here said, I'm sorry, I'm terrible with names, this is otherwise a 6-year statute of limitations would be dropped to a 30-day statute of limitations if this claim falls outside the accounting purview. That language, experts but not arbitrators, has to have meaning. And no one, not the court below, not the respondents in any of their briefs, have ever dealt with that language. And it means that there are limited scope of review. Our claims are not about the calculation. We are not attacking the worksheet. You can review, and I appreciate the extra time, you can review the complaint from stem to stern. That's the document to focus on, not the outside collateral documents they supplied. Waivers should be determined at trial and after discovery, not on a motion to dismiss. And I thank you for your time.
Thank you both. Welman versus Tremont Renaissance.
May it please the court, your honors. My name is Carol Finocchio, and I am here for the appellant respondents, the Tremont Mastermind and Joy entities. We're the ownership entities and the general contractor. We're asking the court to grant us contractual indemnity against Urban Precast. Obviously, they were Joy's subcontractor. They assumed the obligation to do the plank installation, and for safety.
What obligations did Joy have with
Joy
respect
was
to
the-
site safety?
Okay, so while Joy was the site safety coordinator, however, our position is that we could not have been negligent and we did not actually direct and supervise the work, and therefore we're entitled to contractual indemnity. Even though we did rounds and all that sort of thing, this was a means and methods case as admitted by the Orangers who own Newburgh and they own Urban. The edge had to be open where the plank was coming in because in order to do the plank installation, it needed to be open. So that was part of the means and methods of the work. And then safety was the responsibility of Newburgh and New York City Crane.
But under your contract, at least with Joy's contract, wasn't it obligated to install fall protection?
Yes, Your Honor, but this...
So just hear me out.
Yeah, yeah.
Hear me out for a second. So if Joy was contractually required to install fall protection, isn't it a fair argument to make with respect to Joy that they exercise control over the site and the work in that area?
No, Your Honor. Our position is that that is not the case. And the reason that's not the case in this instance is that in order for the work to be done, all of the witnesses testified, there's no dispute that there was no way to install fall protection, otherwise the work could not be accomplished.
But that's fine. Isn't that an issue for trial, though? That the position you espouse with respect to that you had to leave that area open?
No, Your Honor, I would respectfully disagree with that. No witness has disputed that. All of the witnesses have testified. Mr. King from New York City Crane, he was the crane operator, he said that that has to be open because the crane has to lift the planks over. The Orangers testified that it had to be open. Pretty much all of the witnesses testified and nobody disputed that it had to be open. And then...
Well, but Joy's site manager, safety coordinator, stated that he would do walkthroughs to make sure that everything was correct, but he talked about the netting as well in order to ensure that no one fell.
Your Honor, that is a red herring because the testimony showed that this simply could not be done with netting. The witnesses all testified that this had to be open. It wasn't part of the plank installation. I believe, I'm not good with the construction mechanics, but it's my understanding that when the plank comes in, it's actually being laid there, so there's nowhere to put netting.
Okay, so we're not only talking about netting, though, because Joy was in charge of safety precautions to preclude falling, right? Fall protection plan, which included not only a netting, but also harnessing.
Well,
harness.
Your Honor, my response to that simply is that obligation was delegated to subcontractor Urban, who also had a scope of work and safety obligation in its contract with Joy.
So couldn't it be, counsel, that there's an issue of fact in terms of both parties having control, and then ultimately it's an amount of, it's a jury question as to the relative culpability of Joy and Urban?
No, Your Honor, I would respectfully disagree with that. I think, first of all, let's not confuse two things. On the issue of contractual indemnity, even if Joy was negligent, and our position is they are not negligent, because the indemnity clauses, there's two in the Joy Urban contract, they both require indemnity to the fullest extent permitted by law, which basically, I call it contractual contribution. So at the very least, we are entitled to indemnity, at least a conditional order of indemnity to the extent that we were negligent, but I don't think there's any evidence of negligence on our part based on the arguments that are in our brief and the testimony of all the parties.
Well, how about, I didn't really hear an answer to my colleague's question about not providing fall protection. You say it's delegated, but why don't you have an independent responsibility to provide fall protection?
Well, Your Honor,
on an elevated platform.
In all of these contracts, what happens is the owners obviously delegate that obligation to the general contractor, and then in this case, they delegate it to Urban, and then Urban delegated to New York City Crane and Newburgh. So that's what happens all the way down the line. And
Yeah,
that's
but at some point, the delegation has to stop, because at some point, someone has to actually perform the task.
And
They
Your
they have to provide the fall protection.
Absolutely, Your Honor. And the response to that is that it's the party that is actually directing, controlling, and supervising the work that has the obligation.
Or the party who's contractually liable to do so and who states that they will do so under the contract, which appears to be Joy. But we can discuss that further.
Thank you, Your Honor. I'll rest on my brief.
Thank you.
Good afternoon. May it please the court. Jonathan Schaub for the respondent appellant Urban Precast. The Supreme Court committed two errors in this case. First, it should have awarded Urban Precast contractual indemnity against Newburgh and New York City Crane. And second, it should have dismissed plaintiff's Labor Law 200 claim.
Oh, so Urban retained Newburgh to install the planks, and then Urban retained New York City Crane to provide the cranes necessary to hoist the planks into position. Is that correct?
That's correct. And somehow the Supreme Court found that this did not arise out of either entity's work, but the contract provided that there was indemnification required for any loss arising out of, in connection with, or as a result of either party's work. Here, that clearly was the case. This court has recognized that these are broad scope of the work indemnification clauses that apply whenever there's an accident that occurs in the course of that indemnitor's work.
Are you saying, counsel, that Urban we should find that Urban is free of any negligence as a matter of law? I mean, wouldn't you, if your argument's correct, wouldn't you be only entitled at most, as your adversary argues too, for conditional indemnification?
As a matter of law, we were not negligent in this case. The theory is a Labor Law 200 theory, and there's two possible theories in that scenario. There's a means and methods case, which requires the defendant to exercise supervision and control. Here, the evidence is clear. Urban Precast simply manufactured the planks in this case.
There's no evidence that Urban's workers were placing planking.
No, that actually stems from the plaintiff's deposition testimony, and he is basing that on the workers he was working with on the day of the accident. Those workers are indisputably Newburgh employees. There is no question it stems from the plaintiff's confusion. That is not a disputed fact that it was Newburgh's employees and New York City Crane's employees that were present on the job site that day. So there is no question that Urban Precast, again, the manufacturer of the component, they manufactured this and it was shipped by a different company to the job site, installed by Newburgh and with New York City Cranes. We were not there. There is no basis to find that we exercise supervision and control. Now, the plaintiff also has a dangerous condition theory that was alluded to before by your honors. And with that, you must show that the defendant had knowledge of or created the dangerous condition. Here, it was the absence of the orange netting on the leading edge of the cement. Now, assuming this could be a dangerous condition, and we take Tremont's position that it's not, there is no evidence that we created the condition. The testimony from Joy is that netting was present on the morning of the accident. And then the only evidence cited by plaintiff is that some unknown person removed that netting on the morning of the accident. Well, we know one thing. It could not have been Urban Precast because Urban Precast was not at the job site on the morning of the accident. So it could not have created the condition, it could not have had knowledge of it, and it could not have had, that's either constructive or actual.
If a jury were to find, in fact, that Urban's workers were placing planking, could there be a finding that there was, that Urban had some control, sufficient control under 200?
I'm going to push back a little bit on the premise of that, that there's no evidence in the record. That would be speculation because all of the...
Well, there is evidence in the record. You're saying that it's not sufficient.
The evidence in the record is plaintiff. Again, if we review the deposition testimony, the plaintiff testified that the people he believed were Urban Precast were the two gentlemen he was working with. The timesheets affirmatively established that those people worked for Newburgh and were not the employees of Urban Precast. In addition, there's some testimony that he was instructed by, again, who he thought was Urban Precast supervisor not to wear any fall protection. Again, we know from the testimony that's New York City Cranes employee. Nobody from Urban Precast was at the site. And
But you also have LeBron, who is Joy's safety coordinator, who also testified that he observed Urban workers removing the planks, and that he observed an Urban supervisor on the site. So how do you address that?
again, we go back, there seems to be mass confusion here.
Oh, no, there's no confusion because He testified.
He testified to that, but there was Joy is the general contractor on this project. They did not know exactly who the sub of the subcontractor was. The timesheets, the sign-in sheets, the testimony, plaintiff's own testimony as to who he was working with at that time. The only people installing planks at the time of that accident were Newberg employees. And just briefly on the contractual indemnity issue, this is a
And
broad.
I'm sorry, and we know this from the depositions that they were only Newberg employees who were positioning the planks or installing the planks at that time?
There is no other citation to any other person other than Soriano and Colonet, who were the people who were working with the plaintiff at the time of the accident. Those are the only two people that are identified in this record, and those two people are employed by Newberg. There is no
So
dispute
Urban
as
is
to that.
responsible for the planking, for laying the planks, and
Urban is only responsible for constructing the planking. Newberg is responsible for installing the planking, and New York City Crane is responsible for providing the crane that installed that. And just briefly on the contractual indemnity issue, it's a very broad scope of the work. If it would, and this court's precedent is very clear. If the indemnitor's employee was injured while performing the work, that is triggered here. The plaintiff was working for New York City Crane, so they owe indemnification. And in the context of Newberg, it was Newberg's employees who were installing the planking. They were holding the taglines at the time of the accident, and the planking actually bounced off of a guide wire that was installed by Newberg. So that plainly arises out of Newberg's work under any interpretation of the contract.
thank you.
Good afternoon. May it please the court, Christina Mercado for plaintiff respondent. Your Honor brought up the exact point I was going to start with, that Urban Precast says it's only plaintiff's mistake that Urban was at the site. It's not. It's also Melvin LeBron's testimony, page 999 of the record, page 1078 of the record. Urban's own witness, Joe Dunham, testified that he didn't know if Urban employees were there installing plank. That's 1349.
Well, the subcontract has Urban providing and supplying the anything necessary with the erection of the concrete planks, right? But there's nothing that says that Urban is actually installing the planks.
Their contract with Joy says that they contracted to install the plank. They then subcontracted Newberg to install the plank, New York City Crane to provide crane operators, and then another entity that's not a part of the case to provide the
Right, but then so Urban then retains Newberg to install the planks.
Correct.
So if Newberg is the entity that's installing the planks, then how would Urban therefore be responsible?
I guess basically what we're doing is saying that all of the testimony in this case, or not all of it, some of the testimony in the case is mistaken, and so.
Well, see, that's why I asked counsel for Newberg, counsel for Urban, whether there was any testimony in terms of the installation of the planks, and he stated that the only testimony was that Newberg was the one who was installing the planks, and there was nothing definitive that Urban was there installing planks.
There's plaintiff's testimony, there's Melvin LeBron's testimony.
But plaintiff he's not really sure exactly who is installing the planks. I mean, he sees individuals installing the planks, but he's not sure as to whom they work for.
He testified that they worked for Urban Precast, page 586 of the record. Again, if the court wants to find that the plaintiff was mistaken and that Melvin LeBron was mistaken on a motion for summary judgment, I'm not going to argue against that. I just want to say that in this particular case, why it might be a little more confusing than other cases is that Tom Oringer, who was produced by Newberg, testified that Urban Precast and Newberg are related companies that I own. He's the sole owner of both Urban and Newberg. He didn't know if Urban had workers on the site. And William King, who was the crane operator, wasn't sure if he was working for New York City Crane or Urban, that they switched names. So
your position is that the confusion automatically means that there are issues of fact.
Yeah, it's testimony, and it's conflicting. So it's an issue of fact in our opinion.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. My name is Amy Pimer for Respondent NYC Crane. I just want to briefly mention that the court correctly determined that Tremont and Joy's cross-claim for contractual indemnification was correctly dismissed, as we do not have a contract with Tremont or Joy. We see them as incidental beneficiaries, and they were not considered to be third-party beneficiaries under the contract. With respect to the contractual indemnification claims from Urban.
So Urban retained you to hoist the planks?
Yes, to provide the crane and hoist the planks, yes.
Right.
And Newberg was that part of their work was to set the planks, which Urban acknowledged that the only people installing the planks at the time of the accident were Newberg employees. Now, we acknowledge that plaintiff is an NYC Crane employee, but at the time of the incident, the crane actually wasn't operational. They had placed the plank, it had been steady for approximately 15, 20 minutes, and this incident happened when the crane was not moving and they were maneuvering the plank.
Now, the only thing is that plaintiff Skinner works for NYC Crane, is that correct?
That's correct.
And so did the plaintiff not testify that Skinner told him not to wear a harness, or that a harness wasn't necessary that day?
Yes, so that is the testimony, is that it was not necessary because he was supposed to be working a certain distance away from where they would have been dropping the plank, which I think at least all of the underlying defendants agree that the netting needed to be removed so that they could do the work. He wasn't supposed to be close enough to that netting to need a harness.
So Skinner tells him not to wear a harness, but if he had been wearing a harness, perhaps he would not have fallen?
I think that's possible, Your Honor. However, even if we can argue that wearing one would have been safer, that doesn't mean it was required, based on where he should have been away from the opening. With respect to the common law indemnification claims against NYC Crane, which are being pursued by Tremont and Joy, we do acknowledge that we raised this point for the first time in our appellate brief, but as plaintiff was a New York City Crane employee and he is not alleging that he sustained a grave injury either in his complaint, amended complaint, or verified bill of particulars, that there's no basis to sustain that claim, as NYC Crane was his employer. And then just briefly, I'll mention that the last claim that we believe the underlying court correctly decided is that Tremont and Joy's claim for breach of contract for failure to procure insurance also should not succeed. As it was their motion, they failed to put forth the support that the requisite insurance was not provided.
Did you provide excess coverage, just yes or no?
No, excess
So then
coverage was
isn't
not
that-
provided.
Isn't, just based on that concession, isn't that a breach?
Yes, it is a breach of contract, and the underlying court denied NYC Crane's motion on that provision, saying, well, you didn't provide the insurance, so the claim stands. However, on a motion for summary judgment, it was Tremont and Joy's position not only to highlight that it was required, but to provide proof that the insurance was not required, and that's what they failed to do. It's not that they may not ultimately succeed at trial, but they failed to meet their prima facie burden.
Thank you.
Thanks.
Your Honors, again, it's Carol Finocchio for Tremont and Joy. Very quickly, I know I only have a minute. Okay, so on contractual indemnity, I'm going to read you one person's testimony, and that is King of New York City Crane. Joy's site safety person was not required to supervise the installation crew during the plank installation. That's page 2044 of the record. On common law indemnity, we want you to reinstate the contractual indemnity claim against New York City Crane. Our brief shows that we believe we are third-party beneficiaries. I won't run through all the indicia, but I will point out one thing that we think is essential, and there's some cases from this court, one of which I lost, which I think are helpful. The bottom line is one of the indicia, one of the many, is that they had to get insurance for us, but also The sub-contracts incorporated the precise indemnity language that was contained in the hold harmless of the Joy Urban contract. And that's an indicia under this court's cases of Winkler versus Halmar and Castle versus Big Apple Hundy, which I lost in this court. And then as for common law indemnity, we oppose the dismissal of the common law indemnity claim. They didn't raise the issue that they were the employer and the absence of grave injury, and they didn't put any proof in the record, so we're at odds to show that there was a grave injury because we can't do the record on appeal. And that's it. Thank you, Your Honors. I see my time is up. Thank you.
Thank you.
I'll be brief and try to address 3 points. First, my colleague pointed to pages 500 in the deposition testimony relating to what plaintiff understood. The key sites here are record 719, record 722, and record 724 that explains why plaintiff was confused as to who those gentlemen he was working with were employed by. That's 719, 722, and 724. And 2087 of the record is the timesheet that shows that they were Newburgh employees. As to New York City Crane, they're focusing on the moment of the accident. That's wrong for three reasons. First, that's the hammer stroke argument that this court routinely rejects in the context of labor law cases. It's the context of the overall work. It doesn't matter what was happening at the precise moment of the accident. That also wouldn't be a commercially reasonable interpretation of the contract. These are designed to provide stability and predictability to people on complex contract or complex construction projects. If you had to go through and figure out what was happening at the exact precise moment of the accident, that would upset the parties' reasonable expectations. And finally, this court has found in the context or in the McCoy case that hoisting is not the actual act of lifting something vertically. It's broader than that. So that is the explanation on the contractual indemnity. And on Tremont, just briefly, they assert that Urban has conceded the contribution and common law indemnification claims. The condition precedent for that is a finding of negligence, as we've spent the majority of this argument arguing. It's Urban's position that we were not negligent, so plainly we did not concede those points. And unless the court has any further questions, we'll rest on our briefs.
Thank you. Thank you all. Excuse me. Beach v. Giraldi Capital. Justice Singh is recused on this matter.
May I begin?
Please.
May it please the court. Mark Zauderer for the appellants. I wanted to take 30 seconds before turning to the important merits of this appeal on breach of fiduciary duty, faithless servant, and the emails to clarify something that I think has been put into confusion in the respondent's brief. This is not just about an appeal of a pretrial in limine order or an evidentiary order. The first two of the three orders deal with that. There was an opinion and a supplemental opinion. But the trial judge invited, by order to show cause, a motion on notice to dismiss a defense and a related counterclaim based on faithless servant, based on the emails, which was new. And just for your reference, so that I can tie that down, it's in the record at page 810. The judge said, although there is no time limit on making a motion pursuant to CPLR 3211, et cetera, to dismiss the affirmative defense of faithless servant for failure to state a claim due to noncompliance with CPLR 3016B, to plead with particularity, plaintiffs have yet to do so. 48 hours, we made that motion. Then the trial came up, and the motion was not decided until April 13 of 2023. Fully briefed, fully argued, a motion on notice, not simply a pretrial evidentiary motion. So I wanted to make that point because a good part of the respondent's brief raises the issue about whether this entire issue is appealable. And of course it is, and that the April 13 decision is at page 60 of the record. Now, the answer and counterclaims that are involved in this faithless defense based on these emails appears at page 913 of the record and after that. And why is this so important? Well, in the years of litigation and the 2 trials that preceded this appeal, the emails were known about. That's discussed at great length in the respondent's brief. But it was only in the couple of weeks before trial that they attempted to marry this faithless servant defense, which was known and never expounded upon, with the emails that are involved. I'm not defending these emails, but what is critical, I suggest to you, on this appeal.
Is there any case ever that held that someone who sends personal and offensive emails from their private email account could be forced to disgorge all of their salary for years and years?
No, Your Honor. That is the
Anything like
point.
that?
That is the point.
In any other context than self-dealing or something that is of that ilk?
Yes, and that's actually what Your Honor said.
I know what I've said,
Yeah.
but I couldn't find anybody else who ever said
Yeah.
anything either.
That's right. The court has set, the court has set a very high standard. This department, in 3 critical cases, and there's a reason for it when you're talking about faithless servant. People do stupid things, inappropriate things all the time.
Well, he could have been fired for that.
You could be fired for that. But what's critical and why we're here is that on the faithless servant defense, you can claw back potentially all of the compensation, not only what is sought in the complaint going forward, but what's already been paid. So some employee around town, and I've seen thousands, hundreds of these myself in different contexts, I'm sure you have, says something inappropriate or makes a sexual, references in emails. This happens all the time. Now, maybe that employee can be disciplined or should be disciplined and perhaps fired, but that's not a basis for clawing back all the compensation paid or payable to an employee. And the cases in this court, they're in the brief, but I just want to quote from you because they are entirely consistent. The lead case, which has been followed here, is the Blue Banana Group case, 176 AD 3rd, First Department, 2019. It says, this requires the employee to have acted directly against the employer's interests, as in embezzlement, impropriety, competing with the current employer, or usurping business opportunities. And that quotes this department's earlier Veritas
And
capital.
then none of those emails were usurping a business opportunity or self-dealing.
That's correct.
They were private emails between one of the plaintiff, or I'm sorry, one of them and their friends.
Yes,
you
that's
know.
what they were here.
Right.
And that is the concept, that you forfeit your pay, which is a drastic remedy, if you've acted directly against the employer's interest, not performed badly or stupidly, or even in a way that would be subjected to firing. And that is the distinction. I see my time is up, and I've reserved time for reply. Thank you.
Thank you, Anna. Samir Degas and Latham and Watkins on behalf of the respondent. I think the key point here is that these were not private emails. These were emails that were sent from a Taraji.com work address to clients of the firm.
Who were his friends, or this
who were
person's
his friends, but
right?
were also
had nothing to
clients
do
and
with
potential-
work. There was nothing in those emails about work, correct? There were dinner invitations and all sorts of other stuff. Am I right about
The
that?
emails were not, the content of the emails was not about work, but they were
Nothing
sent
having
to.
nothing to do with his work. And let me ask you the same question. Have you ever found a case where something like that would require someone to claw back their salary for years and years and years?
I think there's no case that involves these kinds of facts, though there have been, the Collington case,
No,
for
I
example,
mean,
involves.
I've myself in the Fox, I've seen bad emails, right? I'm just curious as to, these emails are not unique. I'm just curious as to whether you have found a case that says that someone sends these private offensive emails that are not work-related, whether they should be required to pay back their years of
I
salary.
think the key thing is they are work-related, and I'll explain why. They are sent to the work addresses of clients like Credit Suisse that has $100 million invested in TCM, an investor in Credit Suisse.
But they're personal exchanges, and the individuals that they were sent to were willing participants. I mean, Again, they were personal emails, and they were willing participants. It's not the situation as counsel cited to Veritas and also Two Rivers, where you're talking about the employee acting against the employer's interests, as stated, embezzlement, improperly competing with current employers, or usurping business opportunities.
And that is an illustrative list, but there is not a case that establishes a bright line categorical rule. And we're here on a motion to dismiss. It's always
Okay,
a
so
fact
we have willing
sensitive.
participants and we have personal emails. Where is the faithless servant?
That's what I was going to explain. So it is even though these are willing participants, when you send an email to a Credit Suisse account, a third of those emails that go to a trader are monitored by the company to make sure that they comply with insider trading laws. When you send an email to someone at the University of Texas, those are subject to FOIA requests. So there is every chance that those clients could end up seeing those emails and withdrawing their investments from the company.
So is
And that's
that
what
not
makes this case.
perhaps speculative?
I mean, this is a motion to dismiss. We did it, and after this was all resolved, at the trial, we introduced all kinds of evidence showing that some of these clients may well have in fact left the company. That reputation in the hedge fund world is incredibly important, and these are all things that, of course, we're allowed.
But again, I'm going to ask you, because this is not the first nasty, offensive email case, and where a party brought a claim for faithless servant that was dismissed, correct?
This is the first case.
It is certainly not. I've certainly had them. I mean, they were cited in the brief, and I remember the ones that I've had. And we've never said that. Never. That's just not it.
There is not a case, Your Honor, that looks like this. There are definitely, they could be completely private emails that have no nexus to the work. I think that is a different kind of case.
No, that's not it. They were not. There's no case that says that conversations between an employee and another person, which none of these emails have anything to do with the work of either company. So that's the defining issue. Not whether someone could review them and fire you for the purpose because of your violation of company policy. That's not in dispute. That could have easily happened. But whether that is sufficient to invoke a doctrine that would require the person to pay back all of their salary and bonus and everything for years and years and years of work that has nothing to do with the business of the company.
And the termination would fall to the employer of the recipient of the email if that was against their company policy.
But it's not just about terminating the employee. It's about terminating TCM. I mean, if these emails come to light, if Credit Suisse sees this is an email that talks about hunting Jews, hunting black people in Harlem, going to the border.
There is absolutely no dispute that these emails were egregious. It was ridiculous, really, okay? There's absolutely no dispute about that. That's not what we're looking at. You are attempting to claw back, to have a return of all monies, bonuses, and compensation paid to plaintiffs between 2005 and 2008. So 3 years, you want to take back all of the compensation, all of the bonuses, and I guess whatever other remuneration there is, totaling approximately $50 million.
Well, they claim $50 million. Obviously, we dispute that.
Okay, but whatever. But you're talking about 3 years of compensation.
This is conduct, and again, we had 5 other kinds of breaches. They violated the securities laws under Regulation M. They doctored notes. They did steal money. So it's a course of conduct offense. This is one piece of evidence that we want to say rises to the level of being faithless and that the jury should evaluate in the context of the other evidence. And the important thing is here, it imperils the existence of the company, because if you lose Credit Suisse, which is your prime broker, and invest $100 million, that is far more important to TCM than someone who might steal a couple $100 dollars from the corporate purse. And so that's why it's a fact-sensitive inquiry. It's not about the fact that these people could be terminated. It's that they could lose their most important investors. And so on the sexual harassment example, for example, your case, Judge Scarpula, I think it's absolutely true. If you have a couple of instances of sexual harassment that are inward facing, as Justice Masley found, that's very different. If you sexually harass...
That's not the only case that I'm talking about. I'm talking about the entirety of the case law on this subject. And you will not find a single case that would stretch the faithless servant doctrine this far. It's a huge stretch.
So you want us to stretch it to say that in addition to embezzlement and the competing with businesses where it puts the employer in a bad light or a negative light?
It's not a stretch, Your Honor. It's already a fact-sensitive inquiry. You have cases like Collington that involve sexual assault, and that was found to be a potential faithless act. Even in your opinion, Judge Scarpula, when you were contrasting the case in front of you with the Astra case in Massachusetts, you said, well, there was other things like the doctoring of notes and securities violations and stealing money, and that was one piece of evidence. That's exactly what we have here.
No, that isn't the same thing as what you have there. In that case, those facts, you're perfectly free to go forward with your faithless servant doctrine and your claims with respect to established categories of behavior that goes directly towards self-dealing and that kind of behavior. And you're saying you have it, right?
We have it, but the test is, and this is the test from the beginning, you have to act adversely to your employer in any part of the transaction. It has to be substantial material.
You don't have to read the test out to me.
Well,
we all know it. We've read it 100 times.
I agree, Your Honor, but the test is not, here are some subject matter limitations. Emails are out. They're just not the kind of thing. The question is, does it strike at the very essence of the employment agreement? Emails often won't, because emails often will be private conduct. But when you're emailing your key investors, and when you're doing it in a reckless manner that could be exposed and could endanger the company, then it can, and at least we're allowed to present that.
But I mean, I could see if the emails stated that, many of the employees here at this company, at TCM, feel this way, or something of that nature. But the emails tend to be, the emails are personal. They're the views of those individuals.
These are senior people at TCM, and their key role at the company is to be a steward.
It doesn't matter. The bottom line is you have emails between, we'll say, social acquaintances, friends, about dinner, trips. The company name is not mentioned. No employees are mentioned. Okay, it's unfortunate they use the company email and say some really outrageous things, but you tell me, where in the emails does it say anything about the business or the business?
You're in a client service relationship like this.
I asked you a question. Where in the emails does it state about a business purpose or relationship?
It's inherently the case when you were
Is it in there?
sending a
That's a yes or no. Is it in there?
But I think the key point, no, Your Honor, but the key point is that it's not about the content of the emails. It's about whether it directly undermines the interests of the employee and whether it goes to the employment relationship. And when you send it from a Taraji.com email account in a way that can be exposed and in a way that, we saw with the law firm of Lewis Brisbois, they lost 100 people and they maybe will go out of business. Of course, in a world like this where your job is to get more clients, is to make sure your clients are happy, if you send emails to clients that involve this kind of content, that if they were exposed by the people above them, I would really hope that Credit Suisse would say, we're not going to do business anymore if your senior portfolio manager is talking about rolling up to the border and murdering Mexicans, fundamentally dehumanizing content that they call ribald comments. I would call them, bone-chilling comments, and you only think that they're ribald if you don't understand how dehumanizing something like that is. And I would really hope Credit Suisse would withdraw from working with TCM. And that, of course, imperils the relationship. The most valuable corporate asset, as Judge Shailen said in the Scaron case, is reputation. And so you have to look at all the facts and circumstances.
Thank you.
Thank you, Your Honor.
I'm curious, counsel, this is now, we're headed to the third trial on this, right?
Yes, Your Honor.
Were any of these emails brought up in the first two trials?
No, they were not, I believe, introduced to the first trial. There was stipulation about taking out certain names. They weren't done. and they were never married to this cause of action until just before trial. I have nothing
But
further.
obviously, right, if these emails come in, it does put those two people in a much more negative light.
Well, if this faithless servant is out, we've argued that based on the verdict that already is there, it's res judicata, but that's for the trial judge. But that's something for the trial judge to deal with, as long as we contend this faithless servant with the email marriage is out of the case. So we'll deal with the rest of it at the third trial. Hopefully that's the last. I have nothing further unless the court has any questions. Thank you very much.
Thank you. Yes, please.
Questions. So just on the cross-bill issue, there's a sort of direct contradiction between what was said by Justice Masley below, and she specifically said that damages can't qualify because the reduction of compensation is not damages. This court in its prior appeal said the exact opposite thing, and so we think that we're correct on the cross-appeal. On this question of whether it came into the previous trial, it was on the exhibit list of the previous trial. They've known about this for a decade, and they never filed a bill of particulars. They could always have inquired about where this came up and it was never our responsibility to issue, to explain to them exactly how we're going to use every piece of evidence. There's a mechanism under New York law called the bill of particulars that allows for that. And then finally, on this question about other kinds of cases, ultimately they want a categorical rule that says it has to be limited to self-dealing. I should note that this court in the prior appeal, in the August 2016 appeal, specifically, they made these exact same arguments with respect to two other violations. One was the fiduciary duty claim based on a violation of Regulation M, which does not involve any enrichment to Beach and Valero. They said there's no self-dealing, there's no enrichment. They did it for the benefit of the company. So there's a categorical rule against that. This court specifically said no. It said plaintiff's violation of the securities regulation, which caused their employee to incur penalties, is directly against the employer's interest, citing Veritas and Scaron, and they made the same argument with respect to doctoring notes, and this court said similarly, the allegation that Valero destroyed his handwritten notes of his conversations with Paul Taraji, replacing them with word process versions that progressively became more favorable, is, when viewed in the context of the overall counterclaim, so you view everything together, sufficient to support a breach of fiduciary duty. So it is not limited to self-dealing. They've made that argument before, and in this very case, this court has rejected that idea. And I think we should do, should do the same thing with respect to these emails.
Let me just clarify, the emails that you're saying that you can assert an affirmative claim of breach of fiduciary duty based on these personal emails?
We have both a breach of fiduciary counterclaim,
Right.
and we have a faithless fiduciary defense.
Right.
And that's
right. Okay. So, and your cross appeal is from. So, for example, if we found that these emails could not support a faithless servant affirmative defense, that would also apply to the. Are you saying it would not apply to the breach of fiduciary?
no, I think it would apply. Your
It
Honor. I
goes
think-
both ways, right? Okay.
I think it applies both ways. I mean, I do think one important difference is, this question of clawing back all of their compensation that they earned, that applies just to the counterclaim. All that's happening here with respect to the defense is we're trying to vitiate their demand for they have made $8 million as people in their 20s who were working in Wall Street during the financial crisis. They want $60 more million based on a series of secret handshake
Right, and
deals.
they got one verdict, right, for $45 million or something like that.
They got one verdict because,
And that,
because of
well,
this-
whatever. I'm just yes. Okay.
Well, but they were serious. The Regulation M issue was barred from consideration by the jury, and so was the doctoring notes, and this court reversed on those things. So that jury did not have a complete picture of what happened. But all we're saying is, as a defense, so we're not seeking to, with respect to just the defense, we're not trying to claw back the compensation. We're saying that the $60 million, the additional $60 million, one of the things that we can present to the jury is, don't give them $60 million because they violated their fiduciary duties in 5 different ways, and one of the additional ways they did it was these emails, and it's a course of conduct offense. In our jury instructions, we said you have to find a course of conduct, material, substantial, to the essence of the employment agreement. Juries and trial courts are able to figure this stuff out themselves. We don't need categorical rules. Thank you, Your Honor.
Thank you all. Hassan versus Terrace Associates, Acquisitions, excuse me.
Good afternoon, Your Honors. May it please the Court. Scott Horn, counsel representing the appellant in this matter. It's our contention, Your Honors, that the motion court erred in dismissing the complaint on the grounds that the defendant was entitled to EDTPA immunity as a matter of law. Specifically, we submit that the motion court failed to apply the correct mode of analysis, which was established by Justice Higgett in the Townsend and Matos cases early on in COVID-19 nursing home litigation. Now, the mode of analysis that was set forth by Justice Higgett that we request that the court apply here to this case is predicated upon three central tenets. The first tenet is that because this is an immunity statute, it must be strictly construed in accordance with the common law in the state. Secondly, again, because of its strict construction, there must be strict compliance imposed upon the moving party to show that it has met the conditions for immunity. And third, because of the procedural posture, as a 3211A7 motion to dismiss based upon evidence, the moving party must, quote, conclusively establish, unquote, its defense as a matter of law. And we submit, Your Honor, that when the record here is viewed through the prism of these three central tenets, that ultimately the motion for dismissal should be denied because the conditions for immunity have not been met conclusively and as a matter of law. Now, I know that in rendering its determination here, the motion court did not apply this mode of analysis. I would note also that the Whitehead decision from the Third Department recently also did not apply this mode of analysis. We submit that when we look at the issue of what is the quantum of proof that is required of a moving defendant under these circumstances to establish EDTPA immunity, this is a question of first impression for this court. And that's why the mode of analysis that's being applied is so critical. And when we look at that mode of analysis and we look at the three statutory requirements, we respectfully submit that the defendants haven't established conclusively as a matter of law any of the three, starting with the first provision and the first condition, which is that the defendant must establish that they were providing health services, quote, pursuant to a COVID-19 emergency rule. And when we look at the evidence that was submitted by the defendant in moving for dismissal under 3211, we're referring specifically to the Slater affidavit. The Slater affidavit makes reference only to two Department of Health advisories, one issued on March 16th and one issued on March 25th. These advisories appear at pages 110 and 159 of the record. The Slater affidavit also acknowledges that these were not rules, but rather merely provided, quote, guidance, unquote, at pages 75 and 76 of the record. So we submit that right out of the box, the Slater affidavit is insufficient to establish the first statutory precondition to EDTPA immunity.
So Terrace, Terrace Acquisitions, right, is AKA King's Terrace Nursing Home. You're stating that it was not, or has not been established that it is a healthcare professional arranging for providing healthcare services pursuant to a COVID-19 emergency rule?
The pursuant to a COVID-19 emergency rule is the operative language in connection with the moving papers that were submitted by the moving party. So the entirety of their submission in that regard is the Slater affidavit. The Slater affidavit makes reference at pages 75.
Counsel, did you argue that below?
No, Your Honor.
Okay.
That wasn't argued below.
Right, because I thought the argument was that there was, the issue was the legislative act which reversed, I guess, this COVID immunity, and whether or not it was retroactive or not.
That is a threshold issue, and if I just may refer back to the point about it not being made at nisi prius, this question is a question of pure law that would be reviewable
If you
based
have to
upon the
look at
record.
somebody's affidavit to determine whether or not they are a healthcare provider under the statutory definition, how could that be a pure question of law?
Because you're looking at their their submission, right? So does their submission meet the standard?
I know, but if you
the
didn't
legal
raise
que-
that below, no one had an there was no opposition, there was no opportunity to put in reply or anything like that. I can't imagine that we would do that on
Well,
appeal.
the second
Why don't we focus on the stuff that you actually argued below?
Sure. The secondary point here, and indeed a threshold point, is the issue of the retroactivity, as mentioned by Justice Weber. So on the issue of retroactivity, we respectfully submit, Your Honors, that the lower court, as well as the Third Department in Whitehead, undertook a flawed analysis of the retroactivity issue. Both Whitehead and Ruth, for that matter, Third and Fourth Department, were looking specifically for language where the legislature would specifically say this is going to be applied retroactively, but that's
Well,
not the standard.
Isn't that necessary? I mean, when we look at the legislation, don't we have to see exactly obviously what it says? And in this instance, it does not state that it's retroactive.
It does not expressly state it, but that is not what's required under
Well, but in
Regina.
contrast, and I'm sorry to interrupt, but in contrast with respect to when the legislature wanted it to be retroactive, they certainly were able to say it, correct?
That's correct, Your Honor. So
It says Article 30D of the Public Health Law is repealed. This act shall take effect immediately. Says nothing about retroactivity.
that's correct, Your Honor. And so in the absence of language expressly speaking to retroactivity, the common law says that the courts are to look to a whole constellation of factors, including
One would be
remedial purpose.
legislative intent. So if you look at the legislative intent, there is nothing that I saw which would suggest that it be retroactive.
Well, there's the memos, the Senate and Assembly memos, which talk about holding nursing homes accountable for harm and damages
Nothing is
incurred in the past.
conclusive.
Well,
There's
that's
nothing
certainly true, Your
conclusive.
Honor.
I mean, there's some assembly members who say, yes, it should be retroactive. There are other assembly members who say, no, it should not be retroactive. There's some who don't even opine on the issue. So there's no clear legislative intent that can be gleaned that it should be retroactive. So therefore, I would argue or suggest, therefore, that we have to look to the plain meaning of the statute, which again says this act shall take effect immediately.
And that point is well taken, Your Honor. And moving, if you move beyond the retroactivity issue, then we get into the point that I started with, which is whether or not this Slater affidavit is sufficient to establish that they've met their entitlement and met the three conditions for that immunity. And so it's that Slater affidavit, which I respectfully submit, presents a case of first impression for this court, which is, again, what is the quantum of proof that's required, what has to be stated, and what is required under the EDTPA to avail yourself of this strict immunity.
Counsel, if I may, how did the nursing home fail to establish that its care of the decedent was affected in some way by the pandemic, that their response was affected by the pandemic? So how did they fail to do that?
So that's with regard to the second element, Your Honor. And so we submit, when you look at the Slater affidavit, it's very long on general protocols and things of that nature, and very short, if not completely a dearth of information regarding the plaintiff's specific treatment, and that's what the statute says. The statute says, and I quote, "The treatment of the individual was impacted by the defendant's activities in response to the outbreak." So it's one thing for a director of nursing to say, this is everything we did during COVID. It's another thing to meet that strict condition, that statutory language. And that's why I started with the mode of analysis used by Justice Higgett, how important that is. The treatment of the individual was impacted. And so that,
Don't
Your
you
Honor,
think, Counsel, I think this is the problem I'm having, and sort of what Judge Scarpula expressed. Had you raised these, which sound to me factual evidentiary issues, then there would have been a reply. But doing it for the first time here does leave your adversary at a disadvantage because they can't respond. Correct?
Well, that's correct, Your Honor, but it's almost like a summary judgment context where there's a prima facie showing or there's not. So they already made their submission, and we're taking issue with their submission in establishing as a matter of law their entitlement to the immunity. You can't go backfill your prima facie showing on summary judgment, for example. So it's somewhat similar here. The second element, though, that is preserved. So the first statutory condition, I acknowledge, that was not argued in the lower court. But the second, taking issue with the substance of the Slater affidavit, that was preserved, Your Honor. And the third condition as well, that's preserved, which is they have to establish that they were undertaking these services in good faith. And we've submitted evidence in opposition to that, which shows that, well, there are 29 deaths, first of all, at this facility. There were pre-existing documented problems at the nursing home involving infectious disease control. The AG report, which I think really kind of informs the entire analysis and how we went from point A to point B so quickly with the repeal, revealed that there was rampant abuse in the nursing home industry. They were making decisions based upon financial imperatives rather than clinical imperatives when it came time to protect their residents. And so we submit that deciding this as a matter of law based upon a 3211A motion, based upon an affidavit from a director of nursing that had nothing to do with this individual's specific treatment, there should be discovery on this issue at a minimum. And then if
you
after...
have time on rebuttal, counsel.
Thank you, Your Honor.
You may proceed.
Good afternoon, Your Honors. May it please the court. Stephen V. DeBraccio from Wilson Elser for defendant respondent.
Counsel, how do you respond to your adversary's position that in terms of you haven't met your prima facie burden, putting aside what wasn't argued, but at least with respect to good faith, by just sort of talking generally about nursing as opposed to the specifics about the care provided to the decedent?
Certainly, Your Honor. Two answers to that. First of all, and this is very important too, this is an immunity defense, and so the defendant's burden is to demonstrate good faith. It is not a negligence case where the defendant would have to go through the bill of particulars and respond to each allegation. To that point, I refer this court to paragraph 36 on page 80 of Slater's affidavit, where she specifically refers to Mr. Hassan's treatment and explains that his family was no longer able to visit, communal meals and activities were stopped, he was seen only by essential staff, his temperature and vital signs were monitored daily, as were staff, and staff wore personal protective equipment when providing care for these residents. Plaintiff says there's a dearth of information about Mr. Hassan's care. There are 14 paragraphs in Slater's affidavit devoted to Mr. Hassan's care.
So do you have to establish that the facility, that it was a healthcare facility in arranging for or providing healthcare services pursuant to a COVID-19 emergency rule?
Your Honor, yes, certainly. That is the first element. And in addition to the preservation issue, I would just point out two things. One, the emergency rule argument was made before the Whitehead court, specifically page 41 of the plaintiff's respondent brief there, and it was rejected. But more importantly, plaintiff's argument contradicts the broad purpose of the EDTPA, which was to protect healthcare workers in the early days of the pandemic. It is rather counterproductive to pass a statute with broad protections and then apply a highly narrow technical definition of what a COVID-19 emergency rule is. Slater's affidavit at paragraphs 8 and 39 on pages 73 and 81 of the record outlined the Department of Health, WHO, and Center for Medicare and Medicaid Services guidelines that they followed in creating the COVID-19 policy and plan in place. As to the third element, good faith, the plaintiff relies on the Attorney General's report. In addition to the fact that it is not binding on this court, it is not helpful for the analysis of statutory interpretation because it was more concerned with the public policy argument of whether the EDTPA was a good idea versus what the legislators meant when it was passed. It is aggregated to all nursing homes across New York State, so it isn't even specific to Terrace, excuse me. And I'd also point out page 39 of the report defeats plaintiff's entire case. The AG says, the intent of the EDTPA was to support healthcare professionals making healthcare decisions in good faith during this unprecedented crisis. That is exactly what Terrace did in this case. Your Honor, if I might just revert back on the retroactivity point, and Your Honor mentioned this instructions at the beginning, this was very heavily briefed, so I'll just say, I asked this court to follow Whitehead and Ruth, and the mechanism followed there for retroactivity and find that it was not retroactively repealed, excuse me. Plaintiff refers to Townsend and Mattos. Your Honors, Justice Higgitt's interpretation is perfectly consistent with the court below. Justice Higgett stated that it is not merely a hospital or healthcare's care to persons affected by the coronavirus pandemic in the abstract, but it is the care rendered to the person making the claim that is affected in some way. Now, I asked the court to take judicial notice of just the proof that was submitted in Townsend and Mattos. In Townsend, there were two affidavits and 2 affirmations. 3 of them did not discuss the treatment of the resident at all, and the 4th one discussed it, Dr. Wanda Mundegne, in 1 paragraph. And that's it. And none of them discussed how the decedent resident's treatment was impacted. Contrast that with Slater's affidavit, again, 14 paragraphs of treatment, and paragraph 36 explaining the specific impact, not being able to see his family, not being able to eat meals in the dining hall. Mattos is the same. Your Honor, if I may briefly answer that, and then just a minute on the PrEP Act.
I'm sorry, no, you're out of time, but thank you.
Thank you, Your Honor.
Very briefly, Your Honor, I'd just like to touch on the gross negligence point, which I didn't get to in my main presentation. The gross negligence point actually follows on the heels of the good faith point with regard to immunity. So under the immunity statute, in order to establish their entitlement to the statutory immunity, the 3rd statutory precondition is good faith. Assuming that the immunity provision applies, assuming that they did meet all these statutory preconditions as a matter of law conclusively, there's still a carve-out for gross negligence. And we submit that under the unique circumstances of this particular case, the issue of gross negligence should go forward.
Again, did you argue that below?
Yes, Your Honor.
You argued that
Gross
this is a
negligence.
carve-out, there should be a carve-out for gross negligence here?
There is a carve-out.
No, I'm asking you whether you asked the trial court to
I believe that's the case, Your Honor. Yes, that gross negligence was argued.
So what are the contentions? What are the contentions that support gross negligence?
So the gross
conduct that goes beyond negligence, conduct that's almost criminal. What is that conduct in the context of the COVID-19 world pandemic?
Well, I would say the conversation would start with the fact that there were 29 deaths in this facility. And I would say that takes it outside the realm of
29 deaths in the facility is sufficient to say that there was gross negligence with respect to a client when there were no vaccines, when treatment was unclear in the beginning what treatment should be provided.
And I just want to say that your allegation was that the terrorists took no steps. Right, took no steps to prevent infections.
Yes, and that was going to be my next point, Your Honor. So you start the conversation with the 29 deaths, and then the next step of the conversation is that there's a document.
29 deaths as a result of COVID.
Correct, Your Honor. And the second step in this conversation is that there's a documented history, and I see my time is up, if I may just address.
Finish.
Thank you, Your Honor. 9 citations were issued in the time leading up to the beginning of COVID.
The failure to maintain and implement an infection control program.
Precisely, Your Honor.
But again, we're talking about COVID, and we're talking about something at the time that we were not really aware of or knew exactly how to proceed with it.
That's true, but we also have as the countervailing consideration the AG report that says at this same time as federal money is flooding in, that decisions were being made financially to pay, to make payments to executives and things of that nature instead of putting the money towards PPE and protective measures that are required by residents. So yes, I understand that we were all scared during that time, but there's also a countervailing point here, and allowing the gross negligence claim or rejecting the claim of good faith simply allows the case to proceed into discovery. That's all we're asking here, Your Honors.
I think it's more than fear. It's not really fear. It's just in not knowing how to proceed, not knowing exactly how to address the issue. And I think that was one of the things that was also mentioned in, I think, at least Whitehead. But anyhow, but thank you both.
Thank you, Your Honors.
The Mattis Dakron versus the City of New York.
Good afternoon.
How you doing?
May it please the court, my name is David Westerman. I'm counsel for plaintiff's appellant. We ask the court to reverse the lower court's denial of our motion for partial summary judgment. We contend that we proved entitlement under Article 11 to compensation with damages to be determined. The court disagreed with us because of our reliance on change orders. The court took the position that change orders cannot provide for an extension of time. We think that's flat wrong, and we think it's a dangerous decision that threatens the sound contract administration on every contract in New York City, every agency. The contract provides in 5.1 that the procurement board rules are part of the contract and trump the contract if there's any contradiction. The city would say that Article 13 alone controls all extensions of time, and Article 13 extensions cannot be binding, therefore they're of no use, okay? That's not what the PBB rules say.
In your view, do the PPB rules trump Article 13?
Absolutely, and it says so in 5.2 of the contract. 5.2 in the contract says that there's conflict between the text of the contract and the PBB rules. The PBB rules
Now, the rule you're citing is 4-02A1, correct?
It follows through several of those provisions.
But do those rules apply to this particular contract?
Yes, sir, they do. And I'll tell you why.
Sure.
4.2 talks about the fact of changes. A change is any change to a contract, be it a durational term, be it a compensation term, be it a scope term. Any change to the contract has to come through the device of a change order. Change orders specifically under 4-02 can include an adjustment of the contract duration or the term of the contract, okay? Now, 402, Your Honor, you may be reflecting on the fact that there's a line in 402 that says it applies to requirements contracts. But we pointed out to the court in our briefing that the rules apply to all contracts. And when the city added the city council added that line, in the legislative jacket, it said, we're adding that line to make it clear that it applies to requirement contracts.
So it applies to, in your view, it applies to contracts also that have no set term or duration or date of expiration?
Yes, and let me confirm why that's so. When you look at 4.2 and it tells you that A, changes can include extensions of time, it then kicks you over to 403C, which is entitled contracts. And it says that the performance duration of the contract, if affected by a change, can be extended by change order in the change order.
Counsel, let me interrupt you for a moment. Then how do you deal with provision 50G that says that all requests for extensions of time shall be made in accordance with 10, 11, and 13?
Okay, very easily, Your Honor. First of all, it's circular. 13 itself says in 5 and 8, 13.5 and 13.6, that 13 is not.
But you're citing a section that isn't even in any of the sections that extensions of time have to do with, right?
Absolutely not. When Article 13, which is the entire reliance of the city, says you can only get a non-binding temporary extension of time. But 13.5 and 13.6 And that provision says that an extension of time for reasons outside of 13 can be granted by the commissioner, right? And they're binding, okay? Now, if Article 13 was read as the city would have it, and it blocked extensions of time under the PB rules, it would fall, because the PB rules control. And if the PB rules say,
No, I agree, but how about, but the 4.02, it says it of itself says that it doesn't apply to contracts, construction contracts, which have no set date of expiration, right?
no, it doesn't.
Well, I don't know.
Well,
That's what I'm reading in the contract. Is that incorrect? Section 402B1(3) says that it doesn't apply to construction contracts which have no set contract term or date of expiration. Is that not what it says?
I'm sorry, what Romanette are you reading from, Judge?
You're talking about the PB rules.
Correct, 402.
And, right, and 402, PB Rule 402B1(3) says that the rule doesn't apply to construction contracts. This is a construction contract,
Right.
which doesn't have a set contract term or date of expiration. So you're arguing to us that the PB rules apply, but by their own terms, they are not to apply to this. Am I missing something?
First of all, this contract has a set duration. It's got a substantial completion date. We had to complete the project within, I think, 1,150 days. So this contract did have a set duration.
But with contemplating, it doesn't apply to construction contracts. Contemplating, your contract contemplated extensions, right?
Right.
So doesn't the PB say it doesn't apply to those kind of contracts?
I don't see the language you're referring to, Your Honor.
Okay.
But I would say that if you look at 402B1(3, that says extensions of a contract term for good and sufficient cause not to exceed 1 year from the date of extension or current contract, contracts shall be subject to this limitation. That was added by the legislature to make it clear that requirement contracts are included, and the legislative history on that bill says it's not to include construction contracts. Then you bump over to 402C, when it talks about adjustment of time and place of performance, or price and time of performance, and said that the vendor, the contract, may be entitled to a price adjustment or for extra work performed or to be performed further pursuant to a change order. If any part of the contract work is necessarily delayed by the change order, the vendor may be entitled to an extension of time for performance. There are an asterisk that then kicks you over to 403C, which says that gives you the process for giving that extension of time in the change order, and it's by the DDC's ACO, which is the agency chief contracting officer. This is a critical part of contract management, and it's doctrine in the industry that you can give an extension of time by a change order. And if you don't, carry through the implications of you don't. The city comes to us and says, we want you to build 3 more floors on the building, but we're not going to give you an extension of time, right? So I'm now building those floors at the risk of liquidated damages because I don't have an extension of time.
No, it's not that you can't get the delay damages. It's that you don't automatically get the delay damages because you got an extension of time.
And the sole
No, that's correct.
The sole vehicle for obtaining an extension of time is Article 13.
It is not, Your Honor.
Because,
Your Honor, Article 13 itself says 13.5 and 13.6 that there can be time extensions granted outside of Article 13. And if Article 13 were to be read that way, it would contradict the PBB rules, which dominate, which trump Article 13 under 5.2.
So you have time on rebuttal, counsel.
Good afternoon. May it please the court, Kate Fletcher for the City of New York. I believe your honors have understood the contract correctly.
So is Article 13 the sole mechanism or the sole vehicle for extensions of time?
Absolutely, Your Honor.
And does the PPB trump it and turn it into
Article 13 is entirely consistent with the PPB rules. It's true, a change order may be used to extend a contract term. But this contract, construction contracts are governed by the approximate starting date and scheduled completion date. They don't have a set contract term, and that makes complete sense. If you're trying to build a building, the goal is to complete the building. It's not to complete, it's not the 1 year. And
So you're saying that 42B13 does mean that that the other sections of the PPB don't apply?
I would argue that by referring to a contract term, by saying that you can extend the contract term as opposed to you can extend the time for performance, which Rule 402 distinguishes between the two, right? So in 402B, you have the term extend the term of the contract, which is a set term, a contract that has a set term. It then explains in 402C that if a change order causes delay, then you can get an extension of time for performance. And under Rule 403 of the PPB rules, which is labeled extensions of time for performance, you have to go through the process. You have to submit an application. You have to acknowledge that the city can investigate and subsequently assess liquidated
Well, what
damages.
happened? Did that process happen here?
That process hasn't happened yet. That process is triggered when DeMattis seeks a final time extension. You always need to seek a final time extension because the partial time extensions terminate the day before substantial completion. So that mechanism is set up for the purpose of allowing the investigation and analysis of delay so that then a recommendation is made and the corporation counsel and the comptroller and the ACCO or their delegates can assess the situation.
So you're saying this is premature because that process hasn't happened yet. And they might get paid every penny that they're seeking, or they might not, but you have the right to have an investigation and everything else, and they haven't started that process.
Well, the facts have to be determined, right? So the change orders don't say, well, this delay happened on this specific day. The change orders just say, okay, we think an approximate number of days might be needed in some of the change orders. Some of the change orders, they leave that blank entirely. So there's an acknowledgement that some delay may occur, but why did that delay occur? What specific calendar day was that delay responsible for? And was that in any way overlapping? Because remember, any concurrent delay, they can't get damages for.
Right, so you're saying that if another trade was the cause of the delay, even though they got the extension, they wouldn't be paid for that. So the fact of the extension itself doesn't indicate that, okay.
So compensable delays are a subset of excusable delays. Excusable delays are determined by Article 13. And so you have Article 13.3, which sets out the reasons that you might be entitled to an extension, and that would be if your delay is excused. If it's caused by a hurricane, for example, here, Hurricane Sandy, it might be excusable. That doesn't mean that it's compensable because obviously Hurricane Sandy was not the city's fault. So the city cannot be held responsible. It is certainly not the sole cause of any delay that happened from Hurricane Sandy. And so I think in this case, they're trying to short circuit what is a very fact-intensive, complex analysis that has to happen in order to determine what caused any particular day of delay, and in order to determine whether that day was excusable, and then separately whether it was compensable. And they simply cannot do that based on the change orders alone, which is exactly what they're trying to do. If there are no further questions, we respectfully ask that you affirm.
Thank you.
The notion that there's a distinction between the term and duration of performance is sophistry. There was a deadline by which we had to complete this project.
So let me just ask you, for every extension that you got, your argument is the fact that you got the extension automatically meant that the extension fulfilled all the other requirements that were necessary for payment?
No, but it's a piece. Okay, 11.
So how could you say that you're entitled to summary judgment?
Because I'm asking for summary judgment on entitlement. 11.412 requires.
Let me give you the same example that I asked the counsel for the city. If you ask for an extension because one of the code trades wasn't there for a week, and you got the extension, you're saying that even though it was.
No, absolutely not.
So
Absolutely
then
not.
how could you seek summary judgment?
Because a change order is the city telling us to do extra work that wasn't in the schedule and wasn't in the base contract. And we negotiated these things.
So was every change order the result of was every extension the result of a change order?
Yes, that they gave us. Yes, and it was additional time for us to do work that wasn't in the base contract. Okay.
So in other words, I'm just trying to wrap my head around it. So it's your position under the hypothetical just given, if another trade was responsible for the delay, and there's a change order as a result, even though the city had nothing to do with that delay, you're entitled to compensation for that?
The change orders themselves resolve that issue because the change order says, by reason of this change order work, must the date be adjusted, which means it's on the critical path, and under the contract itself, it means there's no other disqualifying.
So in other words, so if a subcontractor is responsible for the delay or causes the delay, you're still entitled to payment?
No, absolutely not. Because we're
that's what you're
responsible.
saying.
That's what you're
No,
saying.
I'm not. I'm saying.
So a subcontractor, a co-trade, another trade,
Right.
is having issues.
Right.
And because of that, there has to be a change order. So now you have a change order, there's an extension. So are you stating that you then would be entitled?
Your Honor, we wouldn't get a change order in that circumstance because we're responsible for the trade and its failure.
So that's what I asked you, whether, so every time you requested an extension, or whenever you requested an extension, it had nothing to do with a change order?
No, it had only to do with change orders. The city comes to us and says, we want you to do this extra work. We negotiate dollars, time, and scope. And then that agreement gets put into a change order, drafted by the city, reviewed by Turner and their schedulers, reviewed by the ACO, reviewed by...
Okay, so the record would reflect, or the record substantiates the fact that every change order was the result of the city's requesting some additional type of work.
Yes, and it's in the justification of every one of the change orders. Okay, so this is the city asking, it's not delay in the sense that we didn't do a set group of obligations within the time allowed. We were given 5 more obligations to do. And that's why it's a mini contract. We adjust our contract, scope, dollars, and time. And it's set forth in the change orders drafted by the city. And I want to make one other point, which I think is a wrong statement of 403C. 403C says a change order can have an extension of time and be given by the DDC's ACO, okay? Which is important because that happens during the job. Or, in the disjunctive, by a board of time extension, which is only convened after substantial completion, and then with all of the information that the council was worried about. Now, let me tell you why the ACO...
Well, you're out of time, so we'll have to, that's going to be a...
Well, it's in our briefs, so...
Great, thank you. Bay Plaza versus Argonaut Insurance.
May it please the Court. Michael Panayotu for Appellants, Argonaut and Colony. The decision and order of the Supreme Court should be reversed. In this insurance coverage action, the exclusion at issue is clear and unambiguous and precludes coverage for accidents where the insured...
Has your client consistently applied this exclusion in prior accidents in the way that you're espousing now?
I think it has, Your Honor.
Haven't there been a number of cases where, in fact, coverage was provided? And isn't this really the first time in these 2 personal injury actions that you're raising the issue?
In the record, Your Honor, I believe what Argonaut and Colony have done is they've tendered the claim to other insurers who have subsequently picked up the defense indemnification of Bay Plaza. So it's not, in this situation, the insurer that was tendered to, which is Harleysville, denied the tender initially, and that's what
created this lawsuit because they didn't pick up for the claim. I should say that it's interesting, Harleysville actually reversed themselves and is now defending the plaintiffs under a reservation of rights in the underlying action. But even putting that aside, even if we handled the claim differently, there's no estoppel here because of the case law.
Not estoppel. We're talking about if there's an ambiguity or not. Because if you handle the claims in a certain way, and there's an ambiguity, there's a doctrine of practical construction, no, that we may look to resolve that ambiguity.
I don't think that it is ambiguous, the exclusion. I don't think it's ambiguous because it simply, let me say this, the prior claims were tendered down to other insurers who picked up, as far as I recall from the record. In this case, that wasn't.
So the exclusion applies, excluding work performed by subcontractors, right?
Yes, subcontractors
with whom Mall 1 directly contracted?
Correct.
Isn't that in itself contradictory as to what that means?
I don't think it is, Your Honor. I think subcontractor is defined in the lien law and just generally in dictionary speak, so to speak, is that any one individual entity who performs part or all of a contract for another entity is a subcontractor.
But the folks that Mall 1 directly contracts with certainly aren't subcontractors. Aren't they contractors?
I'm sorry, can you repeat the question?
When Mall 1 enters into a contract with a trade, that's not a subcontractor, correct?
Well, I think B&G is certainly.
Isn't that it's a contractor?
I think B&G here is certainly a subcontractor. They're an electrical subcontractor. That's what they perform. I think contractor or subcontractor is a distinction without a difference, respectfully, because the wording of the exclusion states that all the contracts need to be routed through the construction manager, which is Aurora. Originally became Whiting Turner, but that's a red herring, frankly. So just to back up, there's really no question that B&G and Mall 1 entered into several contracts. There's no question that the claimants were injured.
Your exclusion says we will not, the exclusion only applies to direct contracts, right, between the Mall 1 and the contractor, and not subcontracts, right? So isn't this a direct contract between Mall 1 and the person who's doing the work?
The B&G contracts,
Yeah.
Your Honor? Yes. This is a direct contract between Mall 1 and not the construction manager. It's a direct contract with B&G.
So then if it says subcontractors, how could that be a subcontract? How could that entity be a subcontractor?
How could B&G be a subcontractor?
Right.
Well, I think that, again, the language of what a subcontractor is anyone that performs part or all of a contract for an individual or entity. I think that's
But it's not performing it for anybody else. It's performing it for the person.
Well, because
You have 5 trades, and they all perform a construction of a building. They're not subcontractors of each other, are they?
Well, I think what happened was the owner directly contracted with B&G to perform the electrical subcontract, the electrical work at.
It's not a subcontract. I guess that's what we're trying to say.
Right, I mean, yeah.
Well, at least it's ambiguous as to
So
what.
under your theory, under your definition, it seems you would never have a direct contractor. You would always have a sub.
Well, I think under the intent of the exclusion, the Aurora was
The only reason why it makes a difference, obviously, is because in interpreting the exclusion.
I understand Your Honor's points. I'll just say that the fact that Aurora was listed as the approved entity that contracts were supposed to go through, and the rest of the documents in the record support that. The way the contracts were supposed to be routed at this project were Mall 1 Bay Plaza was supposed to directly contract only with Aurora. Then it became Whiting Turner, and then Aurora Whiting Turner would then.
No, I agree, but where is it shown as a matter of law that this was Aurora speaking to the person that Mall 1 and said, do this work, and then Mall 1 entered into a direct contract? Because that's the problem. It's inconsistent to say that you call this entity a subcontractor when when they are executing a direct contract.
You have time on rebuttal.
Okay, thank you, Your Honor.
Good afternoon. May it please the court. My name is David Green. I represent plaintiffs, respondents, cross appellants, Bay Plaza, Prestige, and Mall 1.
I want to ask you one question, if I might. I might jump in. Counsel says that they've never interpreted this insurance contract any differently. Do you agree with that?
I absolutely disagree. There are
Yeah, okay, so, because that was my understanding, but, so I would like you to elaborate on that.
absolutely, Your Honor. There are 12 prior cases that were prior claims that were accepted under this policy.
But what your adversary says is because other insurance companies picked up those claims, we were off the hook. We don't have to worry about. What about that?
Well, respectfully, I don't think that, number one, that lets them off the hook. I think that either way, if they've accepted the claim, they've accepted the claim. Whatever they did with it after the fact is up to them, number one. But
They didn't disclaim.
Correct.
As they did in this case, so that's your point.
Correct, Your Honor. And more importantly, I don't know the answer to all those questions because I haven't seen all those claim files, underwriting files. I haven't gotten the discovery. That's another reason that this part of the motion is premature. There's, in fact, 7 questions of fact that Justice Cohen found. This court only has to agree with one of them. Your Honor's correctly pointed out one of them. I can go through several others. I don't need to rehash what's in the papers. We have the arise from issue. There's a question of fact there. We have the relationship between Colony and Argonaut, which is a different portion of the motion, but there haven't been any facts put forth. The point is, movement didn't meet their burden on their motion. 7 questions of fact, this court has to agree with one.
Well, let me ask you this. Doesn't it seem clear from the intent of the contract that the only one that's going to get that's going to be covered is anyone who goes through Argonaut, and everybody else is not? And if it's a part of the contract, even if there's a direct contract between the Mall 1, it's not covered? Doesn't that seem like that's what is trying to go on here?
I understand the point, and the point is taken. I don't know what the intention of the contract was, but I can say, as Your Honor's pointed out, the definition used of a subcontractor, colloquially versus legally, is very important. And here, they're using a specific term in a specific way, and then they're trying to rely on that, and any ambiguity in this contract has to be construed against the insurance company.
It's confusing because it says performed by subcontractor in which the insured directly contracted. What does that mean?
I have no idea. I think that's entirely ambiguous.
I mean, if subcontractor weren't there, if it was just said insured directly, then they'd win, correct?
Perhaps, but that's not what it says. And what it says is very important, and that ambiguity here is important. Justice Cohen pointed out, where do I have his quote? He pointed out there are too many potential, this is on page 6 of his order, there are too many potential issues of fact and insufficient evidence for this court to grant summary judgment based on the motion papers submitted, especially given the awkwardly phrased policy exclusion. He also said that there's 40+ exclusions here, and the layperson could have no idea what most of them mean. If I may, if there's no other questions about this motion, if I may turn to the cross motion and cross appeal, where Justice Cohen got it wrong, respectfully, is at the end of his decision where he said, plaintiffs offer no facts in support of their position, seemingly assuming that any denial of coverage for the Fernandez and Patrick accidents should give rise to a claim against their insurance broker. That's wrong. We submitted an affidavit. The affidavit made a prima facie case of broker negligence and breach of contract. That affidavit and that evidence remains unrebutted. Any arguments that it's insufficient are, number one, wrong, and number two, not preserved. I see my time has expired. Unless there's any other questions,
Thank you.
I'll wait for my reply. Thank you.
Good afternoon.
May it please the court, Gerald William Delaney, Kenny Lasovich, Ryland Wolf, for respondent to cross-motion Fairmont Insurance Brokers. Your Honor, first of all, if you uphold Justice Cohen's decision on the underlying appeal, then the cross-appeal is a moot point. But I think Justice Cohen got this correct in his entirety. As he said, there is no evidence that a denial of coverage automatically means that there was malpractice or negligence on the part of Fairmont. Now, the motion is premature. Justice Cohen held it as to the underlying motion, and it's relating to the cross-appeal as well. The facts that are needed to develop why these were upheld on the prior 12 claims, well, obviously Fairmont saw that these prior 12 claims were not disclaimed. If it was seeing claims being disclaimed, it obviously could have then taken actions to remedy it sooner. So those facts are relevant to the decision as to Fairmont as well. The claim against Fairmont is based on an affidavit. Fairmont has not had a chance to depose the affiant. That obviously right there indicates it's premature. Also, even if we accept the affidavit in its whole, it says that the plaintiffs may have been willing to pay more and probably would have sought additional coverage. But those are obviously ambiguities. We have to interpret any ambiguities, any inferences have to go to Fairmont since it was opposing a motion for summary judgment, and since Fairmont is obviously appealing, or not appealing, but responding to an appeal of a denial of summary judgment, it is entitled to all favorable inferences. It has to be assumed that they would not have sought other coverage and were not willing to pay more. And just briefly, as to the issue that we did not properly respond to the underlying motion, I don't know where that was. As we have responded to every point, we admitted to some were denied, some were denied as legal conclusions, some we could not respond to since we don't have sufficient discovery. But truth be told, I can't respond to that point because the plaintiff's brief does not state where the response to the underlying motion was inadequate, and they also claim that certain points were not preserved. Those were not out on appeal because, for the simple reason that we don't have the underlying brief by Fairmont in the trial court. So as such, that's just almost an ipsa dixit statement that we've gone beyond our trial court brief. Does the court have any questions? Otherwise, I'll just rely on our brief, and thank you again for your consideration.
Thank you very much.
May it please the court, just to address some of the other points that were made by the
Well, why don't you
Supreme
address
Court.
the point that I thought it was an interesting point, that in fact it's not 9 but 12, and that rather than disclaiming, which you had every right to, you accepted.
Again, Your Honor, I don't have the whole file to see exactly what the basis for the decisions were. I will say that in those situations, an exclusion may have been considered, it may not have been considered. I don't know exactly what the basis for the decision was, although, like I said, I think that my point is that it doesn't bind Argonaut and Colony here, in this case.
How we should interpret the contract, right?
I understand, Your Honors. To really quickly touch on a few other points, the main one is the sixth basis for denial, the relationship between Colony and Argo. Colony Specialty really respectfully does not belong in this case. They didn't issue the policy. There's no evidence that they issued a policy here. They're the company that issued the disclaimer letter. The policy itself states that it's issued by Argonaut Insurance Company on page 49 of the record. So notwithstanding the other arguments, I think that Colony Specialty does not belong in this case.
Thank you.
Thank you.
A few points. Very important counsel said he doesn't know the basis or the analysis that was used in interpreting the other claims. That's exactly one of the points I'm making. We need to see that discovery in order to understand what was the basis, and then we can make that determination. As far as Colony versus Argonaut, there's been no evidence to support what counsel says. It may be true. I don't know. We can figure that out in discovery. Policies get bought, and claims get bought and sold all the time. So I don't know the answer. As to the cross appeal, we're not saying that anything is automatic. We're not saying that there's an automatic entitlement to summary judgment if, which we don't think it should be, if the other motion is granted. We're saying the affidavit submitted is prima facie evidence of the special relationship, the specific request.
No discovery. I mean, on one hand, you complain about not having discovery from the other side, and meanwhile, you submit, which I would say, and all affidavits are self-serving, because you construct it the way you want. Why shouldn't there be discovery with respect to all these issues?
Well, an affidavit is evidence. It is as good as testimony.
It's self-serving evidence.
But the law says it's as good as testimony, and it hasn't. Most importantly, it hasn't been rebutted. If there was a competing affidavit that said, "No, we disagree because here's our position," then I would agree. But they didn't put that in. I see my time has expired, so
Thank you all.
Thank you. It's weird being here. Never been last.